Delegate from Spotsylvania, Delegate Cole.
I rise for a point of personal privilege.
Delegate has the floor.
Thank you, Mr. Speaker. Based on several speeches given this session, including today, I feel compelled to share with the body the current state of the law regarding discrimination and to give a little bit of a history lesson about the ERA. Women and men already have equal protection under the U.S. and Virginia constitutions. Courts have ruled both women and men have full claim to equal rights through the 5th and 14th Amendments to the U.S. Constitution. This is why VMI was ordered to begin admitting women more than 20 years ago. Virginia's Constitution also prohibits discrimination on the basis of sex. Additionally, legislators have worked to address equal rights on both the state and national level. There are at least 50 laws in the Virginia Code and more than 125 federal laws prohibiting discrimination on the basis of sex, including employment and equal pay protections. Equal pay has been in federal law since 1963 and in Virginia Code since 1974. Any employers who are discriminating on pay on the basis of sex is already breaking both state and federal law. Now on to the Equal Rights Amendment. Congress submitted the Equal Rights Amendment to the U.S. Constitution in 1972 with a 7-year deadline or sunset clause for ratification to the states. The amendment appeared to be moving quickly towards ratification, with 35 states ratifying it when concerns were raised about potential unintended consequences, including the loss of religious liberties and privacy rights, as well as its impact on the right to life. The ERA language is very broad and allowed no exceptions. A literal reading of the language could prohibit separate facilities for women and men in public buildings, as well as separate programs for boys and girls and teens in public schools. This could not just impact restrooms, but dormitories, dressing rooms at public universities, prisons and jails, the military, programs and scholarships designed to help women and girls. Also, the ERA language gives Congress the authority to implement it, so our rights could be at the mercy of the changing political whims of Congress. Once these concerns were raised, not only did no new states ratify the amendment, but 5 states rescinded their previous ratification. As the original 1979 deadline approached, Congress extended the deadline to 1982. The extension was legally questionable and was the subject of a court challenge. However, when the second deadline passed, Congress declined to extend it again. This effectively withdrew the amendment from consideration. This fact was generally recognized by both proponents and opponents of the amendment at the time, as efforts to get additional states to ratify it ceased for more than a decade. Not only that, but in 1983, proponents introduced a new ERA in Congress because the original amendment was no longer valid. Then in 1992, the 27th Amendment to the U.S. Constitution, dealing with congressional pay, was ratified long after it was submitted to the states for ratification. This caused some ERA proponents to renew their efforts to get it adopted. The fundamental difference between these two amendments, Mr. Speaker, is that Congress did not set a ratification deadline or sunset clause for the 27th Amendment, while they did set a deadline for the ERA. Since the submission of the Prohibition Amendment, Congress has routinely added 7-year ratification time limits, except for 2 proposed amendments: the women's voting rights, which passed, and child labor prohibition, which did not pass. Additionally, an amendment granting full voting authority to the residents of Washington, D.C., with representation in the U.S. Senate had a 7-year time limit and also failed. The passing of the ERA deadline has been recognized by the U.S. Supreme Court. Lawsuits over ERA were pending before the court in 1982 when the U.S. Supreme Court declared those questions moot and dismissed the cases because the ERA had expired. Some ERA proponents want to ignore facts of history they do not like, such as the ratification deadline, the fact that 5 states withdrew the ratification, and also that 24 other states that ratified it placed time limits on the ratification that have long since expired. If Virginia ratifies the old ERA after the fact, it will set off a series of expensive and divisive lawsuits over the validity of the amendment. Regardless of who wins these lawsuits, a large portion of the country will consider the Constitution to be tainted, either with an amendment that is not valid or because an amendment that should be included was not. All this confusion and divisiveness could be avoided by Congress simply submitting a new amendment to the states for ratification. I hope that ERA proponents will spend their time lobbying Congress to submit a new ERA to the states instead of trying to get the General Assembly to pass a resolution that would have no effect or worse, spark a series of costly and divisive lawsuits. Thank you, Mr. Speaker.
Delegate from Fairfax, Douglas Simon.